first installment of payment.
Yes, my lord. That has to be done.
What is the first installment? Where is it?
Well, that,
Even
my
in
lords, will get at clause 8. Please take clause 8.
30% of the value of the inventory.
Yes, my lord.
And
And
fixed
100%
asset,
of
100%
the
value
trademark
of-
shall be made not later than 30 days from this day.
So that is 1
Has
crore
to be
50
made- Yes, my
plus around 2 crores and odd.
Yes, my
So
lord.
3 crore 50 lakhs has to be paid.
Yes, my lord. On or before 7th of May 2024. That is when, my lord, the 30 days will expire.
Innondu 9 lakh, okay, 94 lakhs. So 7 crores get 30%. Yes.
It is not. So therefore, my lord, payment, which is why, my lord, the miscellaneous clause 19 says on fulfillment of the first installment. First installment has to be made within 30 days. 30 days means, my lord, on or before, my lord, 7th of May 2024. Now the actual payment which they make, my lord, is beyond that date, and that is an admitted fact.
And how much payment do they make?
They make the full payment, my lord. They make the full payment of the first installment. First installment, full payment is made, but not within the date. Agreed under, my lord, clause 8. So therefore, my lord, if it is not made within that time period,
Did you terminate this agreement?
my lord, the clauses itself would say that it is not, becomes inoperative, which is why I'm saying that, my lord, it is still at that stage, and therefore, my lord, unless they execute this agreement or ask for specific performance of this agreement.
Not necessary. Unless you terminated this, you received the money, you not returned it back.
We have not returned it back. We have not returned it back, but we have said, my lord, this agreement cannot be enforced. There are various mails which would say this agreement cannot be enforceable for various grounds. Not only this, we also say fraud, my lord. We also
You received the money and retained it.
true, my lord.
Delay ಆಗಿದೆ ವಾಪಸ್ ಕೊಟ್ಟು terminate ಮಾಡಬೇಕು.
Actually, they should have returned the money, my lord, and
Not done that. By virtue of this payment, once the payment is done, though belatedly, they are entitled to use the mark.
What I am told is, my lord, assets, my lord, are in their custody and control. Agreement is terminated.
Where is the termination letter?
I'll show the mail, my lord, where it is terminated.
So at the most, you are entitled to receive the balance amount.
No, my lord. Question is, my lord, if it is termination, unless they challenge the termination in a manner known to law, my lord, the list will not arise in relation to this agreement.
That is a claim statement that they will file before
Correct,
the
my lord.
arbitrator.
They will have to issue a notice, my lord, commencing the arbitration.
You went to court first, what to do?
True, my lord, but nevertheless, my lord, when the termination did not take place after I went to court, termination takes place before I go to court.
So you want them to file a suit,
No, my
or
lord.
issue a notice and then go to arbitration, not in your matter.
Not in my matter, my lord. That is the first
That is
aspect.
the only
Second
condition.
aspect is, my lord, when the suit was filed before the city civil court, they had this, my lord, option available of saying, my lord, section 8 is there. There is a arbitration agreement, and therefore, please send the parties to arbitration. They don't take up that. They say, please see, this court has no jurisdiction. They must agitate all their rights before the commercial court.
They filed an application.
Yes, my lord. Pursuant to which, my lord, it was. Therefore, that is the first statement of defense. Their first statement of defense, my lord, is not arbitration. Their first statement of defense is, you please go agitate all these things before the commercial court.
Page number. When is the first statement that they filed?
Please take, my lord, page number 134. Order. 134 is their first statement of
page number 70.
this is the application which they file, and this is followed by an order. Annexure R8, if my lord sees.
So they filed a complete defense to the application.
True, my lord. Complete, and my lord, no mention of, my lord, saying this court has no jurisdiction for the limited purpose that in 6.1 they would say that, but they don't press it. That is page number 138. 6.1. They would say that there is an arbitration clause, but they don't enforce this. They say, please go to the commercial court.
They did not file a section 8 there.
They did not file a section 8 there.
Yes.
Now please see the order, my lord. Order is at annexure R8.
First shows the order referring to the commercial code.
Yes, my lord. That is what I am showing, my lord. Annexure R8, page 70, my lord, in the statement of objections.
Page
70, annexure R8.
Yes.
So therefore, my lord, Lord, the termination date is 31st May 2024. That, my lords, will get it annexure K. Termination, my lord.
Page
Page 103 in the writ petition, my lord.
yes.
We send a mail, my lord, on 31st May. My lord, terminating this agreement. My lord, it is after this termination, my lord, suit is filed before the city civil court. So therefore, my lord, what I am canvassing before my lords is, after this date, my lord, I file the suit before the city civil court. They don't invoke the clauses of, my lord, the agreement.
Para 16.
16, yes. But they admit the termination, my lord. They admit the termination even through. So therefore, what I am trying to, my lord, canvass before my lords is 31st May 2024 is the date of termination. Lord, please see the
31st May. Okay.
yes, my lord. 31st May. The suit before the city civil court. Is filed as per annexure R. Though they would say, my lord, there is an 6th June 2024, my lord, I filed the suit before.
6/24.
Yes, my lord, I filed the suit before the city civil court.
Yes.
My lord, then the suit, my lord, is held to be not maintainable and we have to go before the commercial court. Plaintiff is represented before the commercial court. And my lord, during this entire intervening period, my lord, there is not one letter, my lord, which they would say that I am invoking or enforcing that agreement. If that would be the case, my lord, the scenario would have been entirely different. If there was, my lord, an arbitration commencement by sending a notice saying your revocation is bad, your termination is bad, that, my lord, under section 21 leads to commencement of arbitration proceedings. If that had occurred, my lord, then, my lord, probably the situation would have been different. This suit is filed, plaintiff is again represented before the commercial court. Even on that day, my lord, there is no invocation or commencement of arbitration proceedings under 21. So therefore, my lord, what would be the subject matter of the case would be whether, my lord, they are entitled to use it or not. Our simple case is, we are the registered owners, they cannot use it. That is the dispute, my lord, which is canvassed before the commercial court. They would, my lord, no doubt produce this agreement along with section 8. But then for them to enforce section 8 of the Arbitration Act, there must be commencement of arbitration proceedings under section 21. Otherwise, my lord, it is an agreement which is terminated. Unless there is a list or, my lord, process set into motion to enforce that agreement, My lord, section 8 cannot be made applicable to them. So therefore, my lord, subject matter, please, section 8, if my lord kindly sees of the arbitration, what is the subject matter? My lord, subject matter cannot be enforcement of this agreement. Assuming, my lord, they put forward a defense in this suit, only for hypothetical, my lord, to see whether, my lord, even then it would pass the requirements of section 8. It is still an executory contract. Section 8, a judicial authority before whom an action is brought in a matter which is the subject matter of arbitration agreement. My respectful submission is, this is not the subject matter of an arbitration agreement.
Yes.
So section 8, my lord, prima facie will not apply. Therefore, my lord, it should be a subject matter of an arbitration agreement, and if a party to the arbitration agreement or any person claiming through him applies not later than the date. So therefore, my lord, if they are trying to get rights under the agreement, enforce rights under the agreement, then, my lord, certainly it is not, my lord, satisfied. Because, my lord, there is termination. So therefore, my lord, that is why I am saying, if they had just issued one notice saying that your termination is bad, there is an arbitration clause. You are invoking the arbitration clause, suggesting the name of so and so. Please give your concurrence, my lord. Then arbitration process has commenced under section 21. Then, my lord, my suit was probably, my lord, not maintainable in view of section 8. This does not happen. Commercial court, my lord, till the date I have filed commercial court, there is no reference to, my lord, initiation of arbitration. Of course, before the civil court, they would take this contention, but not, my lord, enforce it. So therefore, it does not fall within the subject matter of arbitration agreement. And clearly, section 8, my lord, is not complied with. That is the first argument. Second argument, as I pointed out, my lord, it is not the first statement of defense. First statement of defense is, you please go to commercial court. That is where you will have the right to get your grievances redressed. That in fact, my lord, gives up the arbitration clause. Because, my lord, they should have said at the first instance, there is an arbitration. Question of going to commercial court also would not arise.
Yes.
Third aspect, my lord, is the question of fraud. There is an FIR which is unsuccessfully challenged before this court.
What is the FIR for?
Yes, my lord.
Offenses under?
I'll just show that to my lords. Page 96 is the FIR.
406 and 420.
Yes, please, my lord. Then the order is at page number 108.
Yes.
My lord, annexure 8. Sorry, my lord. Annexure N, page number 108. Is the order where, my lord,
Disposed of obliterating the earlier complaint to
yes, my lord, and directing, my lord, that all this material can be used for by the investigating officer, page number 113.
Yes.
Therefore, my lord, on all these counts, my lord, arbitration, my lord, is not efficacious, my lord. In fact, since there are criminal proceedings and various other aspects will be there, my lord, there will be difficulty for the arbitrary tribunal. Last point, my lord, is since it pertains to, my lord, use of a registered trademark, as per, my lord, Vidya Adrolia and all other judgments.
That we may not see.
That
Yes.
Please. May I just place some brief facts before the Honorable Court before addressing the 3 points which the learned senior has raised. Brief list of dates to give the entire conspectus of the dispute before the Honorable Court.
We are not deciding the dispute. The issue is the agreement has been terminated. On the termination, you have not raised any dispute.
I'll directly address that.
That is one. Two is when the suit was filed, you did not say section 8.
That's incorrect. I'll show that as well.
court.
I'll show that as well.
You raised it,
Please.
but you asked for it to be referred to commercial court. Yeah, section 8 is, you did not file an application, section 8.
Section 8 says first statement on the of defense on the substance of the dispute.
On
Now
the
that-
injunction application.
There are judgments which say that that has to be the written statement in a suit. Now, may I just directly take the Honorable Court to the objection filed to the injunction application, Your Lordships, because that is not a correct submission. May I request the Honorable Court to kindly look at page 138, that objections which was referred to the injunction application before the civil court.
Para 6.1.
Please, 6.1, Your Lordships.
Yes.
Your Lordships,
Clause
as stated here,
27
Your
of the agreement reveals so.
we have specifically talked about the arbitration agreement. We have said admitted to execution of the agreement, which provides for arbitration as the agreed dispute resolution mechanism. It is further submitted its contention of defendants that trademarks have been validly assigned to them by the plaintiff, and there is no dispute between the plaintiff and the defendants as has been claimed by the perpetrator representative. In any case, clause 27 of the agreement provides for all disputes and claims, if at all, between the parties inter se to be submitted to arbitration.
Did you file a section 8 application?
Section 8 was not filed at that, but there was no written statement either filed. On the merits of the dispute, there was no written statement filed at that juncture. It was just a memo we had filed.
So your statement about the trademark being assigned is not a statement on merit.
Your Lordship, there are judgments which say that that has to be by way of a written statement. Because today what happens is there was an ex parte injunction passed against us on the 39 application filed by them in the suit. So when we entered up in, immediately we filed objections to that. In that itself, we took up this
Those are the
contention.
judgments.
Your Lordship, that I don't have the judgments immediately because that was not taken up by them before the commercial court. For the first time, it has been raised here. I will take the Honorable Court to the objections filed by them before the commercial court. They have never raised this objection. This was never their contention that Section 8 was not filed before the civil court. It has been filed for the first time before the commercial court. Before this court today, for the first time, it's not even there in their petition before the Honorable Court. For the first time, they're raising this objection. I will address it. The law is in my favor. But in any event, my submission is if the objection which I have filed is looked at, there I have at the first instance taken up this contention. And I have also taken up a contention
Where is
that
the objection filed to section 8?
objection. May I request the Honorable Court to kindly look at that? Say
177.
177 with the petition, Your Lordships. 177 to 182. Annexure V. Your Lordships may kindly see para 11. Specifically, they refer to my contention that it is filed before the first statement of defense. They just say it's false. It was never their contention. In fact, everything which has been argued today was
not
not
there.
argued before the learned commercial court. In fact, may I place one thing? I'm grateful that my senior has gone into the terms
This
of
is
the
because Mr. Abhinav is appearing, is arguing all this. He did not appear
He
there.
did not. Your Lordships, I'm grateful the learned senior has referred to the various terms of the contract because the argument taken up before the commercial court is that I have not entered this contract. In fact, they have not, the contract is not a concluded contract. It is vitiated by fraud. There are multiple allegations made against us. Now, today, they are seeking to defend it by arguing that the performance under the contract has not been done and that an arbitration notice as required under the contract has not been sent. I will directly address that point itself, Your Lordships. May I request the Honorable Court to kindly look at, I have sent out 2 arbitration notices. It is not, my first submission is that the argument that prior to filing a Section 8 application, an arbitration notice under Section 21 has to be issued, there is no basis in law. The Section 8 application can be filed even before the arbitration notice. May I request the Honorable Court to kindly look at my arbitration notice. I have filed 2 arbitration notices. I have sent 2 arbitration notices. May I request the Honorable Court to kindly look at 253 of my objections, Your Lordships. There are 2 notices. The first one is at 253. The second one is at 255. And their reply is there also at the next page. Your Lordships may kindly take that list of dates which I have given. It will just place this in context. Let's just request the Honorable Court. 28th August, I filed my Section 8 before the commercial court. 29th August, the very next day, I send out the arbitration notice. It is not as if I have kept quiet and sat on the dispute. Recently, I've issued a second arbitration notice to which they have also replied. They have disputed. Now, all along, their contention was this is not a concluded contract. There are elements of fraud. It cannot be arbitrated. Today, before this honorable court, they seek to set up a defense that this is a trademark dispute which cannot be arbitrated. Vidyadrolya, I'll take the honorable court. Vidyadrolya itself says that unless there are elements of in rem, public rights, third-party rights involved, it can be arbitrated. The previous paragraph to what the learned senior read. 76, please, Your Lordships. So that argument has been taken up for the first time. In any event, that argument also does not hold water because this is purely, the honorable court will kindly notice clause 19 of the contract, which the learned senior read. There is a clause which specifically states on payment of my first installments, I become entitled to use the trademark. First installment, admittedly.
Abhinav, you want a finding on all these? Or if you have a choice of an arbitrator,
Please.
you can record that. We'll have it on Monday. If you have appeared in the matter, you have taken this content. If you have to deal with all these things, then
This court does not have the benefit of all those aspects being considered for this.
not benefit of.
If you had raised it and specifically.
It
then
is
probably
not the
it would be
question
easy
of,
for-
his contention is not the benefit of, his contention is something different. And if you have to deal it in that manner, you will have, your client will have trouble everywhere.
Versus today, 4.5 crores I have paid him. I'm out of pocket for almost 1 year. He has not paid it back. He has not addressed it anywhere. It is not on record anywhere. He has suppressed it before all the courts.
But then he's using the trademark a lot.
You have you have two things. If you want to settle the matter, what is the amount required? You can tell us on Monday, Tuesday, we can ask them.
Please.
If you want a particular arbitrator to be appointed between both of you, choose the name of the arbitrator.
Please.
That could also be closed. But if we have to deal with your submissions, it may not be.
I follow what my lords are saying.
So that opportunity we'll give it to you before
Yes.
passing the.
Take instructions. Only then I'll be able to.
Shri Abhinav Ramanan, learned counsel for the petitioner, Shri Tejas SR, learned counsel for respondents, relist on 2nd at 2:30 p.m. for further arguments.
Obliged.
Ramzan festival, Wednesday.
Wednesday and a second.
Great.
Further hearing, serial number 2, yes, Shekhar Shetty.
I appear for petition and
Yes, Mr. Shetty.
Yes, sir.
What happened to the, the building bylaws have come in Bangalore.
it has not come, they have not done it, even unless your lordship may be pleased to see. Can they make any building law for anticipate dates?
ನೋಡಿದೀರಾ ಅದು?
ಇಲ್ಲ ಈಗಲೂ ಮಾಡಿಲ್ಲ ಅವರು ಹೇಳಿದ್ ನಾವು ಹೇಳಿತ್ತು ಇದು ಮಾಡಿತ್ತು ಡ್ರಾಫ್ಟ್ ಕಳಿಸಿತ್ತು ಮಾತ್ರ ಹೇಳ್ತಾ ಇದ್ರು
ಇಲ್ಲ ಅದೆಲ್ಲ ಆಯ್ತು ಇವಾಗ. It has
ಇಲ್ಲ,
been
ಮತ್ತೆ-
notified.
ಬಿಲ್ಡಿಂಗ್ ನೋಟಿಫೈ ಮಾಡಿದ ಕಾಪಿ ನಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರು ಕೊಟ್ಟ ನನ್ನ ತಮ್ಮ ಮುಂದೆ ಹೇಳ್ತಾರೆ
ಎಲ್ಲ ಆಗಿದೆ ಒಂದು ವರ್ಷದಿಂದ.
Because last endorsement they are going to me is we refer to the government to consider it.
ಗವರ್ಮೆಂಟ್ ರೆಕಮೆಂಡೇಶನ್ ಬಂತು, ಕಾಮೆಂಟ್ಸ್ ಬಂತ ಆಯ್ತು. Now it is been notified and the bylaws are in force in Bangalore.
Let them
Finally.
give a copy, my lord.
Copy ಕೊಟ್ಬಿಟ್ಟು. Soft copy on Thursday. You are served on Mr. Shekhar Shetty. State has given ante Mr. Shetty.
Pardon me. అవునా?
One soft copy Anil gave WhatsApp ಮಾಡಿ. Learned counsel for learned AGA is requested to forward a soft copy of the bylaws which have been building bylaws which have been brought into force in the city of Bangalore to the counsel for the petitioner to enable the counsel for the petition to make a submission. Relist on 15th April. Only that particular matter should come, not everybody. ಅವ್ರು ನೋಡ್ಕೊಳ್ಳಿ.
15th,
ಇಲ್ವಾ ಹಾಗಾದ್ರೆ 21st ಆ ವಾರ ಯಾರು ಇಲ್ವಾ?
21st
21st
12th is the 21st ತನಕ ಇರಲ್ಲ.
15, 16, 17th ಇಲ್ಲ 21st.
ಅಲ್ಲ ಆ ವೀಕಲ್ಲಿ ಫುಲ್ ಇರಲ್ಲ. ಆ ವೀಕಲ್ಲಿ ಫುಲ್ ಇರಲ್ಲ.
ಯಾವತ್ತು ಬರ್ತೀರಾ ನೀವು?
19th ಇಂದ 21st ತನಕ ಇರಲ್ಲ.
So 23rd. 24th.
Serial number 3, MG Kumar and connected matter.
For appellant,
What is this RFA before us?
blood matter is
appearing for the respondent, my lords.
Huh?
matter is going to settlement. Kindly
Going to
attend third.
settle.
Yes, madam.
ನಮ್ಮದು ಏನಕ್ಕಿದೆ
My
ಇದು?
lords,
Report ಅಂತ.
Special order. Both the councils, yes?
I'm for the respondent, my lords. My lords, it's listed on 2/4. It's before the mediator. I'll request a date, my lords.
Third gaki.
Both the councils submit that the matter is listed before the mediator
Yes, ma'am.
on 2nd of April.
Yes, ma'am.
And there's a likelihood of settlement being reported by then. They request for the matter to be taken up on 7th.
Third madam. ಇಲ್ಲಾಂದ್ರೆ 8th.
ಅಲ್ಲಿ ಕಾಪಿ ತಗೊಂಡ್ ಬರ್ಬೇಕಲ್ಲ.
8th madam.
8th relist, and they request for the matter to be taken up on 8th, relist on 8th at 2:30 PM. Parties ಬರ್ಬೇಕಲ್ಲ.
ಹೌದು sir.
Yes, madam.
So 2:30, keep the parties present.
Right.
Much obliged.
List number 2, order serial number 1, NS Sheshadri.
For the fourth respondent in this matter, my lord,
Hmm.